Okay, we're going on the record on cause number DC 212328 Wile E. Coyote versus Axiom Financial LLC. Excuse me. Counsel, make your appearances.
Yes, Your Honor. I'm Stuart Cochran with Steckler, Gresham, Cochran, Cherry, here on behalf of the plaintiff. With me in the room is my associate, Blake Mattingly, and my paralegal, Lisa Medelis. Also here is the client representative, Joel Locker, appearing by Zoom.
Okay, Ms. Boyce. Ms. Boyce, we can't hear you. Ms. Boyce, you're connected to audio, so go ahead and unmute. You need to unmute. Okay. Go ahead.
Sorry, I was on a different line trying to get audio in. Reagan Boyce with Chambly Ryan. I'm here on behalf of the named defendants in this matter. Also present is Senior Director of Axiom Financial, Mr. Kenneth Alexander, and as a corporate representative for that entity. Also present as a corporate representative for FFC Capital Ventures is Mr. Will Bird. I also have present on behalf of Axiom Financial, the Director of Communications, Mr. Joshua Kaltfed, who are also here in a corporate representative capacity, Your Honor.
Okay, so off the record, we had a discussion of kind of about where this case is. Set on the docket today was a temporary injunction. I'm not sure if the contempt was set. I didn't see that. The only thing I believe is set is the temporary injunction, but you said there might also be a motion for contempt that was set for today.
Yes, sir. We filed a notice of hearing last week. Lisa, did we communicate with the coordinator? Or did
Yes.
We did?
Yes, Dr. Rhonda.
Yeah, Rhonda was aware we were setting it, Judge. We sent the notice of hearing. Is my understanding.
So let's kind of unpack everything that was discussed. So as I understand it, there's an agreed temporary injunction that's been signed but not submitted. Is that right?
That is signed, Your Honor. However, due to changes in circumstances, I would like to be heard on that before it is submitted to the court.
Okay, what's going on?
Just briefly, when the original TRO was signed by agreement, all of the named defendants agreed to be subject to the TRO in order to expedite reaching an agreement that would allow Axiom additional time required to repay the ICA payment at issue. I'd like to be clear that Axiom has never denied that the funds are owed. It has acknowledged its obligation to repay those funds to Wile E. Coyote. The other named defendants, both the individual defendants and FFC Capital Ventures, are not party to the contract, which is at issue here, Your Honor. And as explained in our response filed earlier today, they have no control over Axiom. They agreed to enter the TRO against them simply in order to help assist Axiom in any way they could to work out arrangements to have payment remade. When the TRO was extended, at that time, I requested with Stuart Cochran that he ask his client to please release the individual defendants and FFC from the agreed TRO and continue it against Axiom only, as Axiom is the party to the contract. Axiom is the party that has acknowledged the obligation to repay, and Axiom is the party that has done everything it can to show that it is still acting in good faith to make that repayment, including paying the requested sanctions, agreeing to entry of the TRO without need of a hearing, and agreeing to the entry of the preliminary injunction. At the time that the TRO was extended, which was 2 weeks ago, Axiom represented to the other defendants that it believed it would be able to make the payment within the extension time between the expiration of the current TRO and the requested preliminary injunction. Although the defendants had requested that they be released from the proposed preliminary injunction, plaintiff was unwilling to release the additional defendants from the preliminary injunction, and the only way to secure that was to agree to signing off on the preliminary injunction. Axiom Financial is here today.
When you're saying preliminary injunction, do you mean temporary injunction?
No, there was a there's an agreed preliminary injunction that was required to be signed off on by all the defendants in order to get the TRO extended from March 15th.
I don't believe under Texas law there's no such thing as a preliminary injunction. You mean a TRO?
I'm sorry, the preliminary injunction and the TRO. There's two different documents that we were asked to agree to. One is the preliminary injunction that we're here to have them submit to be entered today. And then there was the extension on the TRO that was pending. So the preliminary injunction that the plaintiff is asking this court to enter, it's not just against Axiom Financial, the party to the contract. Plaintiff is asking that the court enter a preliminary injunction against the individuals as well as the other entity, the intermediate broker.
So what did you sign off on? Agreed temporary injunction as to all defendants? We
did, and we also, at the time, because Axiom had believed that it would be able to make the payment before the expiration of the extended TRO, we were also asked to sign off on the preliminary injunction being requested by the plaintiff in the event that Axiom did not make the repayment within the TRO timeline. That TRO expires today. We're here today. Plaintiff is asking for a preliminary injunction. We agreed to that at the time, believing that it would not be an issue getting repayment made because Axiom was taking efforts to procure alternative funding. I would like to clarify just for the record that Axiom is still waiting for the ICA funds to come back from its TPA, and that has been the entire holdup to this process. Axiom has also undertaken to acquire intermediate funding from other sources in order to expedite repayment of the funds to Wile E. Coyote. These representations have been made to counsel and they were made to Wiley before this process started. Axiom is acknowledging that it owes the ICA payment back. Axiom has stayed in communication with Wiley, and once counsel was engaged, communications have continued with counsel. Axiom has done everything it can to show that it is acting in good faith to make the repayment of the funds requested. I'm here today simply to request that the court consider that the individually named defendants, Mr. Alexander, Mr. Welsh, Mr. Bird, and the other entity that Mr. Bird and Mr. Welsh work for or associated with, which is FFC Capital Ventures, which simply acted as an intermediary between Wiley and Axiom, not be included in the preliminary injunction. Axiom is the party to the contract. Axiom is the party that received the funds. Axiom is the party that has the obligation to return the funds, and Axiom is the party who has agreed and acknowledge its obligation to return those funds. So to the extent that the preliminary injunction is being requested as against all defendants, Your Honor, we very respectfully request that the court consider the circumstances, and if it's going to enter the preliminary injunction, do so only as to Axiom Financial LLC at this time.
And Your Honor, if I may, that's just simply not what we agreed to. We named all of the individual defendants because they were all, and I need to choose my words carefully here, Judge. My client has been told different excuses, to put it mildly, at every step of the way. Mr. Alexander was never available for a meeting in person with my clients. Every time they tried to set up a meeting, he was unavailable. Tried to set up a phone call with Mr. Alexander, who was with Axiom. He was unavailable. They dealt primarily with Mr. Bird and Mr. Welsh, who, although on paper worked for FFC, they were agents of Axiom. They were the ones that were out front telling Mr. Locker and Wile E. Coyote that the money's coming, the money's coming, the money's coming. And not until we put our foot down and filed the case and moved for the TRO, do we finally have them here. And so not only is this what they agreed to, I don't want to speak for my client, but I don't think that we would have agreed to extend the TRO another 2 weeks and let all the others out if we knew that this is where we're going to be. I think we would have moved forward with the injunction hearing 2 weeks ago. So, I asked that the defendants be required to honor their agreement, which we agreed to 2 weeks ago, to move forward with this temporary injunction against them all. Not only that, we do have live claims against them for fraud in real estate, fraudulent inducement, and a bunch of other things that are not at issue here, obviously. But they're part and parcel of the deal. And it's time for my client to get his money back.
So as I see this, I really have two choices as a judge. Either I enter the agreed order, which is something you guys have all submitted, or I guess you haven't submitted, but if you submit it and it's agreed to, or I have to have a temporary injunction hearing on this, which could take some time. But I don't know that I can just come in and say, no, I'm only going to make you agree to part and not to all. I guess I could do an agreed one as to Axiom and then have a hearing on the rest. But if that's what Mr. Cochran wants, but I don't see how I can just say, oh, I'm just going to have this as the Axiom if that's not what they agreed to.
We certainly, well, number one, we expect that the defendants will live up to their agreement for extending the TRO and being here before you today on this agreed injunction. To the extent the court is disinclined to do that, I certainly would like a temporary injunction certainly issued against Axiom, which is true. They are the signatory to the development line of credit. They're the ones responsible for paying the money. So yes, Judge, if to the extent you're inclined to bifurcate any of this at all, certainly would like an order today. Would like it against everyone. If I don't have that option, I certainly want it against Axiom. And I would like to move.
And then have a hearing as to the rest. Is that first off, let me just say this. That was just a suggestion. I kind of feel like the only thing that I can impose is either if you have an agreement, I can do the entire agreement. If you don't have an agreement, then we have a hearing. If Ms. Boyce has indicated that she would agree to an injunction against Axiom, assuming that that's the case, we could enter into an agreed temporary injunction now. I don't know that I have time to do a full injunction hearing today as to the other defendants, but we can, schedule that and get that set if that's what y'all want. Ms.
I think
Boyce,
my clients would like to be heard as to the individually named defendants, Your Honor. Again, they really, when they agreed to the original preliminary injunction, it was with the understanding that Axiom was believing that it was going to be able to comply within the time constraints and it wouldn't have been an issue. Obviously, all of the defendants are interested in assisting this process going forward, getting the return of the funds expedited. And so that was the reason behind the agreement. I believe the situation has changed slightly now that that we are in this state and that there's no longer an agreement for the plaintiff to allow more time for Axiom to comply, other than the fact that Axiom acknowledges its obligation. It has acknowledged, and I'm representing to the court today, that Axiom intends to fully repay the ICA funds and does not object to the preliminary injunction if plaintiff feels that is necessary to compel compliance, which has always been agreed to from this point forward. But I think my other clients would like to be heard on the matter of preliminary injunction, Your Honor.
One thing I would say, if it's up to Mr. Cochran, is I do think that there's a potential claim for breach of contract against your clients for signing this kind of I'm just going based on what you're saying. I don't know that this is the case, but for what Mr. Cochran has said is if they did sign this to kind of induce him to agree to this extension of the TRO, they could be subject to a breach of contract claim just for that. I mean, that's something they may want to consider.
I talked to my clients about that, Your Honor, but I know that in discussion going into today, we wanted to put evidence or at least have our position heard with the court that there's really not proper grounds for the preliminary injunction as against my clients, based on the information that we've been provided to date by plaintiff and the circumstances as we understand them.
And then we also have the contempt issue. What is the contempt? What exactly?
To Crystal, let me ask one more question, Judge. I'm sorry before I address that. Mr. Mattingly told me I might have misheard you. Was your question, do I want you to enter the agreed temporary injunction as it is today against all the defendants, or do I want to wait and have a hearing against the other defendants?
No. I mean, if you guys all agree and you submit this, I can sign the agreed temporary injunction, but it sounds like there's not an agreement. And so just to make my position clear, I don't think that I can enter it if there's no longer an agreement. That being said, Ms. Boyce has said that they do agree as to Axiom. So if you want me to enter it as to Axiom, I could do that. And then we could have a hearing as to the rest. I warned Ms. Boyce that I said, look, if you signed off or they signed off on the temporary injunction, there is a potential that Mr. Cochran could sue on behalf of his clients for breach of contract for inducing him into agreeing to the extension of the TRO and signing off on that and then withdrawing their consent. I think that's I don't know the strategy or kind of what it smells bad. I'll just say that, to induce someone into agreeing to an extension of the TRO, and then on the day of the temporary injunction saying King's X, I don't agree anymore, is not how I would recommend people practice law in my court, at least. But I will obviously hear all the arguments and hear everything that people are saying. Just doesn't sound good.
Your Honor, if I may, can I request the 5-minute conference to confer with my clients and resume?
Well,
just
but
so
before
that
we do,
having
can,
heard court-
I can put you into breakout room. I have no problem with doing that. I do want to figure out this contempt issue. What is the contempt about?
Yeah, the issue is real simple, Judge. You signed a temporary restraining order requiring them to pay us $500,000 by March 5th, and they didn't. It's that simple.
And are you asking to put them in jail, or what's your requested remedy?
No, Your Honor, I wouldn't presume to tell you what the appropriate remedy for you.
No, that's not what I'm asking. I'm asking, what are you requesting, not what I'm going to do.
I think the maximum you can fine them under Texas Government Code is $500. I would request that you fine every defendant $500.
So you're not the reason I'm asking is that if you're requesting potential jail time for these folks, I can't do that over Zoom. There is no Zoom jail. I can't put them into a breakout room for the next 6 months. And so that would need to be a live hearing. So if you're requesting jail time, then we would need to have a live hearing on that. And that's why I'm asking the question.
Yes, Your Honor, we are not here today requesting that they go to jail.
Okay, so we could do the contempt potentially today. I just want to make clear, if you're requesting jail time, I don't have, the one area that I'm doing live hearings on is potential contempt cases where somebody's requesting jail time. So if you're not doing that, we could go forward potentially today, but I don't know that we have time. Okay, so that answers my questions, Ms. Boyce. Who do you want me to put you into a breakout room with?
I will need the Axiom Financial, which is Mr. Alexander.
Give me 1 second, because I'm going to just hit these one at a time.
Okay.
All right. Okay, the number 990, is that one of yours?
Josh, is that you?
990. Everybody unmute. 990, is that one of the attorneys or one of the people?
I'm not sure if that's Mr. Colbert or not. I can't tell from here.
Okay,
Guys, you need to unmute.
I unmuted.
Are you 990?
I can't see that it says 990.
The last 3 digits of your phone number
Rob
is
Welch.
990.
Oh, no.
That's Rob Welch's phone.
Oh, okay. So I
Okay.
need that phone number 990.
929, is that, who is that?
I don't know who that is. 929 is not us.
929, who is that? That Axiom Financial, Clint
need-
Corey, do I need to put him in the room?
No. I need Rob.
Don Tittle?
No.
All right, I'm sorry, people keep coming in and out of the room, so I messed up my assignment.
That's okay. I need,
apologize. No,
990
wait, I'm sorry. Somebody just, I have to start over again.
Okay.
Sorry. Okay, 929, do I assign them to your room or not?
No.
990 is gone. Clint Corey, do I assign him to the room?
No.
Don Tittle?
No.
Joel?
No.
No, okay. Joshua?
No. Yes.
Reagan Boyce?
Yes.
Yes. Rob Welsh?
Yes.
I do assign him to the room, okay.
Yes. And Will Bird.
Rob Topham?
No.
Will Bird?
Will Bird. Yes.
Okay, and then Reagan Boyce.
Yes, Your Honor.
Okay. All right, you guys should be getting invitations to breakout rooms. Go ahead and go there, and then you guys can, when you leave the room, it'll say on the bottom. Sorry, they already left. Reagan, I'm going to send you to the room with them, and just tell them that, just go there, tell them that they can leave the room by looking at the bottom right of the screen where it says leave room. Make sure they just leave room and not leave meeting. So it'll say leave breakout room or leave room. Just go there, tell them that, and then come back, okay?
Okay.
Hey, Judge,
1 second.
I'm sorry.
And make sure you're loud when you go in there, because I don't want you accidentally listening to attorney-client privilege, okay? So unmute, go ahead and unmute, Reagan. I'm sorry, someone was talking to me.
Yes, Your Honor, it was me. There's a number of folks on the call. I don't know who they are. I don't know if they're here for this hearing or for another hearing. Could we identify?
So Maximilian Achetti is my intern. Samantha Favela is my intern.
Okay.
There's a Joel here. Is he your client?
Joel's the client rep. Yes, sir.
And then Reagan, did you already tell him?
Yes, I did.
Okay. And Don Tittle, I think, is here for another hearing. Is that correct, Mr. Tittle?
Yes, it is, Your Honor.
And Mr. Topham, are you here for another hearing?
Yes, I am, Your Honor.
And Mr. Corey, are you here for another hearing?
Yes, sir.
Okay.
Thank you, Judge.
And then Rhonda Pinson is my court coordinator and Tony Rieger is my court reporter.
Thank you.
Okay. Well, I guess we'll wait for now. Let me see about the next hearing. Is everyone here for the 2 o'clock that needs to be here?
I believe so, Your Honor.
Let me just pull that up and give me 1 second. And is that on the motion to compel in the Rotino case?
Yes, Your Honor.
Okay. Tony, are you ready? Tony, are you ready? Tony, are you there? Tony, are you ready?
I'm sorry, I'm hitting mute, but yes.
Okay. Let's go on the record on cause number DC 1817623, Chris Rotino versus Joshua Garza et al. Counsel, make your appearance.
Your Honor, this is Don Tittle on behalf of the plaintiffs. I'm also joined by Roger Topham, who is an attorney in my office and who will be presenting the plaintiff's position today.
Your Honor, Clint Corey for the defendants, Joe Garza and Garza and Harris law firm. And I just wanted to make sure, do we have a court reporter?
We do. We're on the record right now.
Okay, great.
And that's Tony Rieger. You can see it right there on the screen.
Thank you.
All right, let's go ahead and go forward with the motion to compel. Movement, you may begin.
Sorry, Your Honor, I had to unmute myself there. This is Roger Topham for plaintiffs. As you know, we're here on a motion to compel. Essentially, there's a number of requests at issue here, but basically boils down to a fairly wide gulf between the parties as to what's discoverable in this case. And it requires a bit of a, well, the scope is a bit broad because of just the nature of the case. This isn't a typical malpractice case where you've got an isolated instance of a lawyer dropping the ball with regards to a particular client, and that's it. This is really about a plan that Garza was executing for years in the course of representing many different clients. He even admits in his own declaration that he had hundreds of clients executing essentially the same transaction. And it's, the allegations involve, basically say that he sold this scheme. It's like what you'd call a multi-step financial scheme to avoid or to decrease paying taxes or minimize your tax burden, where all these different clients, including all the plaintiffs and a number of other former clients of his who also were audited by the IRS and had their deductions disallowed under the same plan. And a number of those clients or former clients are also suing him. So this is the claims go, they do reach beyond the plaintiff's files, essentially, and Mr. Garza's files on the plaintiffs. And I'll talk a little bit more about that in a second. Just as a quick aside, I mean, as I said, many of his former clients are suing him. After they were audited, he was the subject of an FBI investigation that was related to, as he points out in his declaration, a healthcare fraud investigation into several of his clients who all used the same private annuity transaction. And just as an example of the kind of the way Mr. Garza has been approaching discovery in this case, we requested and made a request for disclosures almost 3 years ago at the outset of this case when we filed the original petition, which of course involves a request to disclose insurance agreements. It took many months to even get the first one. It took several months more to get a second insurance agreement. We proceeded to spend an entire day meeting.
Mr. Topham, I've read everything, so let's kind of get to the
Sure, absolutely.
the lick log. I'm just a little tight for time. I apologize. I don't mean to.
Oh, understood.
So let me just kind of say this. I've read the motion and most of the response, although that was quite long, and I just got it. So, but obviously there's an issue here about attorney-client. The Garza defendants are attorneys, correct?
Yes, they are.
Right. So there's going to be an issue as to attorney-client issues involving the other potential clients. And so the original named defendants, were they all other professionals, or were some of them clients of the Garza defendants?
They were all professionals of one type or another, either attorneys or law firms or accountants or accounting firms.
So how do you deal with the issue, I guess, of you're asking for all, I'm looking at request for production number 1, you're looking at producing all emails between you and any of the original named defendants in this case between January 1st and 2013. If those communications relate to the Garza plan, I'd imagine a lot of those may be attorney-client, may have attorney-client communications, I would assume, correct?
Well, some of them might. The thing is, though, that this is, how do I put this? I'm not sure. I have no reason to believe that every single email between, just for example, Joe Garza and Kevin McDonald was specifically related to the representation of any particular client. At some point, whenever this big ball of wax was forming at the beginning, McDonald may have contacted Garza. I mean, we have reason to believe, actually, from talking to McDonald's attorney, that McDonald contacted Garza just in a sort of general sort of way, not related to any particular client, and to just simply discuss this plan that Garza was offering to his clients. We also know that.
So I guess my question is, how do we deal with the issue of attorney-client? There's one way we could deal with it is order it all to be produced, and then they could make a privilege log, although I worry that could be quite voluminous if there's a lot, if you said there's hundreds of different clients involved. We could limit it to just the initial formation of the Garza plan, if it's clear what the Garza plan is.
Well, I don't know that there are really that many emails. In speaking with Mr. Corey, he contends that Mr. Garza really didn't send very many emails. And so I suspect that in most of these emails are going to just, and this will come up in another request later, it'll be say, for example, Mr. Perry attached his some information about a client of ours who needs a corporate valuation letter, and here's the letter. Can you please fill in the blanks and sign your name and send it out to these clients? And there would only be 1 or 2 of those emails per client, so I don't think it's going to be necessarily that voluminous. And for each individual client, there was only the accountant who did the corporate valuation and a lawyer who sent out the legal opinion letter. So you're talking about a handful of emails per former client. It's not going to be, where all of those defendants were not involved in every client. They kind of each had their own.
Okay, so let me just stop for now. We're going to go off the record. did you guys work everything out? Ms. Boyce, what did you guys decide?
Thank you, Your Honor. In speaking with my clients, they are interested in trying to move the process forward with the least amount of controversy, and therefore they will allow and agree to the entry of the preliminary injunction that was previously signed on the terms that it was signed on, in a show of good faith that they are all working towards a resolution of this matter and in order to move this forward without the need for further hearing today, Your Honor.
Mr. Cochran, is that okay with you?
As far as the preliminary injunction, yes, Your Honor. Again, I would reiterate that I think we need a date certain by which they're required to pay, which is not currently in there.
So let me say something again. I don't think I was very clear earlier. Under Texas law, we have TROs, we have temporary injunctions, and we have permanent injunctions. Preliminary injunctions, I think, is something you usually see in federal court. So when you say a preliminary injunction, are you saying a temporary injunction? Or are you saying a
being requested, Your
temporary
Honor.
injunction? Okay.
Temporary injunction.
That's okay. I just want to make sure I'm on the same page. So does the temporary injunction have a trial date associated with it?
I don't believe we've seen a trial setting in this case yet, Your Honor.
Well, in order for me to enter a temporary injunction under Texas law, I have to have a trial setting included in the temporary injunction, because temporary injunctions can't last forever unless it disposes of the entire case, which it doesn't sound like it does. Is that correct?
Your Honor, it does recite that it will be valid pending final hearing determination of this cause, or does not have a date certain for the
It
trial.
has to have a date certain. I've been actually reversed on that point. So I know quite directly that that's the law. So when do you want to set this for trial?
Of course, on the plaintiff side, as quickly as possible.
Mr. Chambly's trial calendar is pretty full until the end of the year, Your Honor.
You want to shoot for January 11th?
Sure.
Okay, so include in there a trial, and then we need a bond amount. Is there a bond amount in there?
There is not, Judge, because it was agreed to. I didn't think we needed a bond. Is that inconsistent with the law? I'm apologize. I don't know.
I think you can agree not to have a bond, but it needs to say that. It can't just not say there's a bond, just not discuss the bond. Boyce, do you agree there doesn't need to be a bond?
That's fine, Your Honor.
So the parties have agreed that the, I'm sorry, Tony, this should be on the record. Did you?
I've been on the whole time.
Okay, good. Sorry, that's my fault. So you've agreed that there would be a no bond is required. Everyone's agreed, and then we have a trial setting. So I think we're good. Can you go ahead and email Rhonda once you have that done with the changes? Try to email that to her today and tell her to forward it to me immediately, because I know the injunction, the TRO expires, I think, today. And then what about the contempt? How do you want to deal with that?
Well, Judge, I'm sorry, before we move on from the temporary injunction order, sure. What do we think about a date for them to pay by? Of course,
what, Ms. Boyce, what do you think about that?
Your Honor, that has been part of the problem all along, is that we're consistently asked to give a date certain, and Axiom, unfortunately, does not control the entire process. So for me to commit to a date, it would be an arbitrary number. I could ask for 30 days. I can't guarantee it'd be 30 days. It could be next week. It could be 31 days. I really honestly don't know how to answer that question, Your Honor, because Axiom does not.
You guys have to agree to something. So what can you agree to?
I need to talk with Mr. Locker, but here's the thing, Judge. This interest credit account, per their agreement, says will be used solely for paying interest on the loan. They weren't allowed to go use it to invest it somewhere else, to go put in some other deal, to pay some other injunction.
Mr. Cochran, you've already won this. You just need to tell me. I'm open to suggestions on what you want to do.
3 days.
Okay, well, that doesn't seem like that's going to happen, but Ms. Boyce?
It's just not it's not feasible. I would ask at a minimum 30 days, but again, it's an arbitrary number.
Your Honor?
I can't rule on this without a full-fledged hearing, so you guys have to agree.
May we?
I mean,
please-
and let me just say this to you, Ms. Boyce, and to your clients, is that if I have to rule on this and it turns out that everything that's being said is true, then I would order it to be paid the next day because it should have been paid a long time ago.
Correct.
So if everything is true, I'm not saying that I'm going to, but if everything is true, I would order it to be paid the next day. So I would encourage you. I understand you kind of want to, your clients kind of want to wash their hands and say, hey, you know, it's out of our control. You know, they kept the money that wasn't theirs allegedly. And so you got to come up with a number that you guys can agree to.
I would propose 30 days minimum, Your Honor.
Mr. Cochran, what do you think of 30 days?
Judge, I don't want to lengthen this longer than possible. Would it be helpful to you to hear from Mr. Locker as to why this is impacting his business and why he must have the money?
To be honest, it doesn't, because as I said, I have to have a full-fledged hearing. If it turns out everything you're saying is true, I would order it to be paid tomorrow. And if it wasn't, they would be subject to be held in contempt. But this is a business deal between you guys. I can't just order them 14 days or 21 days or without a full-fledged hearing. So, and I'm not even saying I'd enter the temporary injunction. I have to hear all the evidence, but assuming that everything is what everyone says it is.
I'm sorry, you cut out the Your Honor.
Assuming that everything is what everyone says it is, I entered a temporary injunction, I would order it to be produced today. I can't just randomly pick a day for you. You guys have to agree or I have to have a hearing.
Ms. Boyce, let's split the baby. What about the end of next week, 14 days?
My client's asking me to ask for 90 days. That's the direction you want a date by which we can give you some certainty of repayment. That's what I would offer is.
Then I think, Judge, let's set a temporary injunction hearing and let's move forward.
Let me just say this, Mr. Cochran, is this has no teeth unless you move forward with a contempt with jail time. I mean, because all I can do is 500 days plus jail time unless you put something else in there. So, but we can have a full-fledged hearing if you want. I could probably do it tomorrow morning, and we can do that. And we could maybe, I don't know this for sure, you need to research it, or maybe we could just do it on just the issue of how long they should have to pay. But if they really, everything you've said is true, I would have to order tomorrow. I mean, if it's true, and then you'd have to make a decision if you want to move for contempt, assuming that if that happens, then you would have a determination to make. I'd enter a temporary injunction, order them to pay the next day. They're not going to pay the next day. And then either you move for contempt and ask for jail time, or we're just kind of spinning our wheels here.
Okay, I'm prepared to
Your
move.
Honor, I'm just to make you aware, I am actually scheduled to be in deposition tomorrow, and
I'm sorry about that. It's gonna be tomorrow. You'll need to get, you have a very good firm with very good lawyers there. You can get somebody else to cover.
Absolutely.
This is your client's decision that they want to wait 90 days. That's kind of ridiculous based on what I've heard.
We'll be ready tomorrow, Your Honor.
If I can speak to my clients one final moment, asking if there's any timeline that they're offering to do 30 and 30 days, I think is reasonable.
Well, you said 90. Now you're
I
saying
said
30.
my client was asking for 90. They would agree to 30. If Mr. Cochran will agree to 30, I can sign off on 30 right here on the record right now.
Mr. Cochran, can you agree to 30?
Judge, I need to consult. I hate to waste your time, but I need to consult with Mr. Locker.
Okay, what I'm going to try to do, this will be a little complicated. So I can't send all of you, Ms. Boyce. Can I just send you and your Axiom financial person? Or do you need to talk to everyone?
Judge, I'm sorry to interrupt you. How about if I just go in the other room and call Mr. Locker from my mobile, then we'll come back.
Oh, I'm not as worried. It's just two of you. I can, whatever you want to do. Do you want me to put you into breakout rooms or what?
No, sir. Let's make it
fine.
I'll step out and call Mr. Locker on his mobile. He'll step away and we'll be right back.
Okay.
Is that okay?
Ms. Boyce?
I have authority from my client to agree to 30, Your Honor.
Okay, let's see what he says.
There you go.
Okay, Your Honor, thank you. Consulted with my client, the land deal that this money was supposed to be used for is supposed to close in 30 days. That's a non-starter. We'll agree, Ms. Boyce, to be paid by Friday, or we're going to move forward tomorrow.
But I need a moment, Your Honor. Are you able to, let me see.
Ms. Boyce, we can hear you, just FYI, so you want to mute.
Yep, that's what I'm doing.
Is she back or not, or did she go? She disappeared. It looked. No, she is. Ms. Boyce, you're gonna need to come back.
Sorry, Your Honor. Just trying to explain the outcomes that the Axiom is facing based on the options offered. My client will agree to 14. I would very respectfully request that it be 14 days, Your Honor. This week is already 1 day over. It's asking blood for a stone at this point. Axiom would request please 14 days to hold the funding.
Not a request to me, it's to Ms. Cochran.
I
So,
understand, and I'm
Mr. Cochran, I will say that there's, always a risk in the injunction you could lose. So, 14 doesn't seem unreasonable to me, but it's your call.
It's my client's call, really, and
Your client's call. I'm sorry.
Yes,
Your
sir.
client's call.
Yes, sir.
But I understand your frustration. I'm not trying to fuss with you.
I,
Do you want to call him again, or what do you want to do? You want me to put you in a breakout room, or
no, sir. He said no.
no?
No, we'll move forward tomorrow.
Okay.
Can we have till Friday then, Your Honor? I mean, I'll see what my client can do in the meantime. You offered Friday. I mean, we'll do our best.
What do you say by Friday? The hearing
You're
be on
asking
Friday,
to be
or
14 days. Any time possible to give me and my client time to try and make the payment, Your Honor. I mean, we're trying to comply here, but you offered till Friday.
oh, I did. I think he did, but I didn't. Are you saying
If that's all
till
your client's willing to
Ms. Boyce? Are you saying till Friday to have the hearing, or till Friday to make the payment?
make the payment, was my understanding that they would allow the extension for the temporary injunction. Am I losing you?
Mr. Cochran, do you agree to Friday? If I understand, that's what she's saying.
She's offering that we put a date in this agreed temporary injunction that they will pay by Friday. Yes, sir, we agree.
Ms. Boyce, do you agree?
That's what I've been authorized to agree to, Your Honor.
All right, let's go on the record again. Tony, are we on the record?
Yes, Judge.
I want to go on. I want to make sure this is clear. So the parties have agreed to a temporary injunction that the payment, the $500,000 payment will be repaid by this Friday, that the trial would be set for, I think, January 11th. There's not going to be a bond required, and the payment would be made this Friday, and it's been agreed to by all parties. Is that correct, Mr. Cochran?
Yes, Judge.
Your client representative, if he could say he agrees.
Joel?
Yes.
Ms. Boyce?
Yes, Your Honor.
And have each of your clients please indicate their agreement.
Ken, can you agree on behalf of yourself and Axiom, please?
I agree on that for Axiom.
All right.
Mr. Welch?
That name again, please.
Kenneth Alexander
Yeah.
for Axiom Financial LLC.
The other defendants?
Mr. Welch? Can you go off mute and confirm?
Yes.
And Mr. Byrd, would you please go off mute and confirm?
Yes.
Is that all the defendants?
Yes, Your Honor.
Okay, get me the order as soon as you can, Mr. Cochran. We'll go ahead and sign it. I'm glad it all worked out, and I hope it does work out. So I hope it's the last time we have to see you on this stuff. So good luck, everybody, and you guys are excused.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. So we're going to go back on the record on this motion to compel. Let me hear from the defendants on this now on request for production number 1. Tony, do you need the cause number on this?
Are we still on the Rotini?
Yes, Rotino.
Okay. Okay. No, I don't need it.
Okay. So we're going to request for production number 1.
Well, Your Honor, can I address a couple of things before we get to the specific request?
Sure.
Okay, first of all, just so the court knows the status of the case, there's been exactly one deposition taken in this case, and I took the deposition of their expert. They have not taken any depositions. They are taking Mr. Garza's deposition tomorrow. Therefore, almost everything that's in their motion is sort of these hit and run allegations about Garza got sued by all his clients. He did this, this tax scheme. None of that stuff is factual. There's no factual basis for any of it. It's all allegations, and allegations don't define the scope of discovery. What I would like to focus the court on is page 5 of our response. If you'll look at page 5, you'll see there in our footnote 9, you'll see their definitions, which I think is the problem here. Obviously, they have a broad definition of documents, as they, as most parties do. But it's when you get down to paragraph 8, the Garza plan refers to the financial plan that forms the basis of the plaintiff's claims. This includes not only specific individual plans by these plaintiffs were advised to utilize, but also any plans the Garza defendants advised other clients to utilize where those plans also purported to offer tax relief, employing a private annuity agreement between corporate entities formed by the clients. A couple of things about this case, Your Honor. First of all, there's been no adjudication by the IRS or anybody else in this case that there is something wrong with this plan. There's been no adjudication by the tax court that this is a faulty tax scheme or a faulty tax shelter. What happened in this case was that the plaintiffs hired counsel when they got audited by the IRS, and their counsel made a deal with the IRS for them to pay their taxes, which they're obligated to pay by law, to pay their back taxes. And they took, I believe, a 5% accuracy penalty. So this is not some kind of a fraudulent tax scheme that's already been determined by the tax court or anybody else to be something wrong with it. So our position, Your Honor, is, and then as it relates to these other lawsuits, to my knowledge, other than this one, there are 2 other lawsuits. That's it. They have not been sued by all their clients. As Mr. Garza said in his declaration, they did do this transaction for a number of clients over the years. And I believe that resulted in a couple of audits, and we have provided this information to the plaintiffs that through our expert witness, that a couple of these audits resulted in public, no change letters. In other words, the IRS reviewed it and made no change, which effectively approves the deductions. So we've identified in there, in our response, Your Honor, if I can just cover a couple of things. One is, again, they're trying to define the scope of discovery by making these allegations, these broad allegations. Secondly, this is the analogy of a product liability case is a faulty analogy. They say in their papers that this is like a product liability case, and automotive manufacturers, we should discover all of their communications with anybody regarding the design of this product. Well, the problem is automobile manufacturers don't have attorney-client privileges and work product privileges with their customers. So I don't think the analogy flies. It's not like, and Mr. Garza's affidavit states, this is not a piece of software. It's not something that's off the shelf that they sold to clients. It is a part of an estate tax plan. It is specific, even though some of the similar documents would be used with various clients. It is it is specific to them. It's based on their age. It's based on their income. It's based on how many kids they have, what their life expectancy is. There's a number of factors that go into it. There are discounts under federal tax law that are applied. And so this is not, it's not what they're describing, Your Honor. And Garza, they have done this for a number of clients, and they were successful. They were not audited. The fact that they were sued by several clients because they got audited, their expert witness has already testified that the IRS periodically targets different types of transactions. This particular transaction got on the IRS's, we believe it got on the IRS's radar because, I don't know if the court's familiar with the Forest Park Medical Center.
I am.
The Forest Park Medical Center was a prosecution by the U.S. Attorney's Office that dealt with healthcare fraud, kickback scheme among some of the doctors that were involved in there. Mr. Garza was not raided by the FBI. What happened was, when the U.S. Attorney's Office was investigating some of these doctors that were indicted in the Forest Park Medical Center deal, it turns out that several of them in 2010, 2009 had done a private annuity with Garza. And so basically the FBI was gathering up all the tax documents, any related businesses that these doctors were involved in. And so,
Right. Okay. So let me just say this. This is a motion to compel, and I only have a limited amount of time, so I need to get through these. If you want to try to argue any of these individually, I need to be able to get to them. So I appreciate all the background. I did read your briefing, and so
sure.
Let's go to number one at this point. So let me stop sharing this. And we'll go ahead and share it.
This is Don Tittle, and Mr. Topham is arguing for the plaintiffs. Could I just make a very, very brief comment?
Extremely brief.
Okay. This case was mediated early because the reason there's been one deposition is all the other defendants agreed to mediate early, and we had a successful mediation, but for the fact that Garza and his client did not even notify the insurance companies necessary to get anything done. We have been asking for deposition dates for months from Mr. Corey, and we don't get them. So I do object that it's being suggested that we're being dilatory. Anyway, I said I'd be brief, and I'll let Mr. Topham handle it here. But to say that what Mr. Corey said is accurate, it's not even a close representation.
I appreciate all that. Let's get to request number one. So there's a variety of ways we could, I think that some of this would probably be discoverable. Probably all of it is not going to be discoverable. I'd like to not have this where every single communication, Mr. Corey, how many of these plans were there that your client, if you know, recommended that would be part of, at least according to their definition of the Garza plan, would have occurred between 2013 and 2017?
Well, they don't necessarily define it that way. That the Garza plan, every single one of these requests, Your Honor, and I've highlighted it in our response, starting at page 19, and we have a specific response to each one of these. Every single one of them incorporates the term the Garza plan, which means they're asking for.
Right. What I'm asking you is how many different clients were there, according to their definition, did your client provide advice on during that time period? How many plaintiffs?
But let me, if I can focus the court, this plan was done in December of
Mr. Corey, I've asked you this twice now, and you're not answering my question. Please answer the question. How many clients, I'm really doing this to try to help you and try to understand kind of what's going on. How many clients did the Garzas or Mr. Garza advise according to their definition of the Garza plan in that time period? So I have a feel for how broad the scope is. How many?
I don't know the exact number, Your Honor, but it's probably 10 to 15.
10 to 15.
Can I say one thing, Your Honor? The relevant time frame is the end of 2013, because the they took the deduction in tax year 2014 and 2015. So in other words, whatever we did after the fact wouldn't even be, even if it wasn't privileged, it wouldn't be discovered, it shouldn't be discoverable because it's not relevant. What they did after the fact.
Okay, thank you for providing me that information. All right, request for production number 1. I'm going to overrule the objection. I'm going to limit it to, what I'm trying to figure out is how to limit this. One way to do this, if it was only 10 or 15, then I would say, make a privilege log if you think there's anything that's attorney-client privilege. Otherwise, it's go ahead and produce it. The next one is number 5. Okay.
Your Honor, I think we've already responded to this. We don't have any communications with the IRS. I mean, any communications that they had were verbal with the IRS, and we've already responded to the request that we don't.
Right, so the objection to number 5 is overruled.
Your Honor, we don't have
any. There may not be any communications, but if there is any, you need to produce them. Request production number 7.
It's already been responded to.
Okay. All right.
Your Honor, presuming that we've finally gotten all of the insurance policies, we can withdraw that.
Okay. Request production number 11.
And just to maybe make this easier for the court, 11 through 15 are all related. They can be grouped together. They all are essentially, so in it, for every client, there was a legal opinion letter that was provided by an outside lawyer, and there was a corporate valuation letter that at least was supposed to be provided by an outside accountant.
How is any of that not, wouldn't that all be covered by attorney-client privilege?
Yes.
Well, it's essential for our case. To show that, these legal opinion letters were identical. If he's Garza is arguing that all of these different clients, he individualized them all and analyzed each one individually and et cetera. He also promised them, it has to do with the negligent misrepresentation claim. He promised them before he became anyone's attorney, that he would provide, part of the selling point was that he would provide these independent valuations and independent legal opinions. And the truth is that they were not independent. They were simply rubber stamped, and these outside lawyers didn't do their own research or anything else.
And they have no evidence of that, Your Honor. They have no evidence. That's just their opinion.
We absolutely do have evidence of that. We have our own 2 clients got identical. Dr. Phelps got an identical legal opinion letter to the one sent by Rotino and Pace from a different attorney.
Your Honor, if I can address this thing, I've had this.
Okay, guys, 11 through 15, I'm going to sustain the objection.
At
number 16, number 16.
I've had this conversation at length with both of them. This is not what the standard of care is. The standard of care is not to show that he used similar documents in other transactions.
What are you arguing number 16?
I'm sorry.
Because I've already ruled in your favor on 11 through 15.
Okay.
Are you asking me to reconsider?
No.
Okay. So 16, I'm going to overrule the objection.
All right. I'm going to need some clarification on that one, Your Honor, because we've conceded that we conducted seminars. We don't know. I don't know if I can put my hands on one that is dated at a time when their client might have seen it and might have been influenced by it. If I can, I will, but I don't know that I can.
Well,
I have one that's dated. I have one that's dated in 2016, but they actually did the transaction in 2014.
So if you have one for 2016, you need to produce it.
Okay, but how would that be relevant to their decision to do the transaction?
The standard isn't relevance. The standard for discovery is not relevance.
Well, I know that, Your Honor, but I'm just.
So I'm not trying to, I honestly am not trying to be disrespectful in any way. I'm just trying to rule on these. I've made my ruling on 16, so you need to go ahead and produce any documents responsive to 16. Number 17.
17 is going to be related. That's a typo where it says RFP number 12 there. That's a typo that Mr. Corey and I have discussed, and I think we all understand that that's a typo. It's referring to RFP number 16. So these are just communications related to those marketing events.
I don't see any relevance of that. I'm going to go ahead and sustain the objection to that. And not just relevance. I don't know how that could lead to the admission of discovery.
Well, it's only in that, to show that Garza had previously decided that this was a good plan, and it's sort of a one-size-all good plan for everyone. And he's instructing, the former co-defendants in this case, most of them presented that these marketing productions, and it sort of would show that Garza was essentially putting words in their mouth and telling them what to say, and that this wasn't a bunch of independent lawyers all advising that this was a good plan.
So 17, the objection is sustained. 18, the objection is overruled.
Yeah, we don't have any responsive documents, Your Honor. I think the answer.
That's fine.
We don't.
The objection's overruled. You just say you don't have any responsive documents, but there's no objection. So you asking just about generally, not as to a particular client for number 19?
Correct.
Okay, if it's not related, so let me make this clear. If it's not related to a particular client, then okay. If it's not related to a particular client, if it's just a general, you got legal advice from, I guess, but how would that would still be attorney-client because they're advising the Garzas as a client, wouldn't they be, about whether or not this plan is valid, correct?
I don't believe that would necessarily be the case. I mean, if what this is sort of aimed at is, at the beginning, if Garza is going to testify that he performed any kind of due diligence as far as researching or talking to other lawyers about whether or not what he was planning on doing here was going to be legit and pass muster with the IRS.
I can see that. I'm going to go ahead and, if it's as to an individual client, the objection is sustained. As if it's general advice about the legality of this plan from an outside attorney, then that objection would be overruled, and you need to produce it. Does that make sense, Mr. Corey?
Yes, Your Honor.
Okay. Number 20. How's that different than the previous one, I guess?
I believe it's the same. It's just referring to accountants as opposed to lawyers.
Okay, so same thing as 19 and 20 are the same. I don't know who Al Pugh is. What is this?
Al Pugh was another former defendant who did the accounting work for Rotino and Pace when they were using the plan.
Well, why does his compensation matter in this case? Bias or something?
Well, yeah, and just again, it's part of the illusion that he was selling that all these when he represented to the clients that it wasn't just Joe Garza telling them this was a legit plan. All these other accountants and lawyers did too. So when Rotino and Pace were looking for an accountant to do it, he said, "Oh, use Al Pugh."
I'll overrule the objection to that.
Your Honor, I think we've already we've responded. I don't think we have any documents. So
That's fine. Okay, guys, anything else?
Yeah, Your Honor, can I bring one thing to the court's attention?
One last thing, I'm sorry.
Yes.
How much time would it take you to respond to this?
I have no idea what the volume of these clients is I mean, I told you 10 or 15, but I don't know if that's the case or not. So I mean, I think it's going to take several weeks.
How long?
I don't know.
Mr. Topham,
how,
what is your request?
Well, I believe we're set for trial in, I can't remember the date off the top of my head, but I believe it's at the end of May.
Is it jury or non-jury?
It's a jury trial.
I'll give you an update on that. So, and you have a deposition tomorrow. All right, I'll give you 14 days on this. Mr. Corey, you said you wanted to raise something else?
Yeah, I just wanted to show the court that this is not, they're not at disadvantage. If you look at Exhibit C to our motion, I'm sorry, Exhibit B, there's a chart there. If you look at the chart, it's all the documents that they've received from all of these clients that they've settled with. It adds up to about 20,000 documents, Your Honor, regarding this case. So now what they're talking about is trying to expand the scope to probably another 20 or 25,000 documents. And
Appreciate that.
Your Honor, we didn't control how many documents other defendants dumped on us. And the fact is, Mr. Garza he's literally just producing insurance policies within the past month. It should have been 3 years ago. We are entitled to this information from Mr. A lot of this could have been avoided if Mr. Corey had just said, we don't have these documents, I'll withdraw the objection, which we asked half a dozen times.
Okay, guys, let me just say this. So let's talk about the trial setting on this. The civil district judges voted last week to start up jury trials again on June 1st on a very limited basis. So if you're set at the end of May, we won't be having jury trials. I'm happy to reset this case now, or if you guys want to confer with your clients and each other and get back to us, that's okay. But I just wanted to let you know that if you're set at the end of May, it will need to be reset. In June, we're going to be starting on a very limited basis. So what essentially is going to happen, as I understand it, is that all of the civil district judges who participate, who want to do jury trials, and the 2 juvenile district judges who have agreed to participate in this will be assigned a day approximately every 3 weeks where they can pick a jury down in the central jury room. So it's going to be pretty limited in June. You probably want to move it beyond June. And you don't have to decide this today. I just wanted to kind of get you the information. So any questions about that?
Judge, may I ask, realistically, what time frame would we be looking at for when I guess I'm asking you to predict when COVID's going to end. I realize as I was saying that, but if we don't want to just set it for July and probably not get reached, are you looking at more the end of 2021?
What year is this case? 2018?
It's an old case.
Yeah, I mean, I'm hoping, and I think it's not an unreasonable hope, though, no guarantee, that we'll start with a fairly regular jury schedule at some point in the fall. We do have a lot of other cases that have been reset, as you can imagine. And so I think your chances of going, given the age of your case, in the fall it's not, it's reasonable, but not likely. Reasonably possible, but not likely. It would really be the next year that you'd have a probability you would go. But that being said, that's kind of, I wouldn't try to set it during the summer. If you want to set it in the fall, I think there's a reasonable possibility. And then in next year, you'd have a better chance. But I don't know how much time it takes to get this case ready. I don't know how long it's going to be. Have you guys even gone to mediation yet?
Yes.
We have mediated.
With you guys have all gone to mediation? Okay. So it's up to y'all, but I would say definitely not in the summer. You'd have maybe in the fall.
Are you setting cases if it's just assumed that both parties decided we would rather not get a setting that's possible but unlikely, and we wanted to just shoot for February of 2022? Are you setting cases then?
Yeah.
Okay.
But I would say if you want to, the farther you go into the year, next year, like April is probably more likely than February, but it really is, there's no guarantees at this point because no one has ever done this before. We've never had over a year off from jury trials and then another, who knows, 2, 3, 4 months of limited jury trial. I mean, it's hard to predict, but I would say that, sometime in the April, you'd have maybe a probability, but a slight probability you could go. But again, if you said I want to try to reset it in the summer, I think it's extremely unlikely. In the fall's reasonable possibility, a slight probability sometime in the spring.
All right. Thank you, Your Honor. We'll submit an order on the rulings.
I would, if you can send that to me so I can look at it.
Send it to Mr. Corey. One other thing I'm asking with this kind of age of COVID, as I've learned, helps me a lot. If you could put on the order the date that this hearing occurred, it gets really difficult, especially if you wait a couple weeks for me to figure out. I have so many hearings and I can't take notes on this system. And so I'm taking notes on a notepad. If you could just put the date on the hearing, that would help a lot. And if you could get everybody to sign off as the form, that'd be even more helpful. But at least put the date of the hearing on the, so instead of on this day, say on March 29th, the court heard the following, blah, blah, blah.
Certainly.
And then we do have a transcript and a YouTube recording of this. So if you need to go back and look at it, you can. All right, guys, you guys are excused. I'm going to, Mr. Harder, I saw the other attorney here, Mr. Leidick. I'm going to take a quick break and I'll be back in about 5 minutes.
Thank you, Your Honor.
Okay, guys, sorry about that.
No problem.
Okay, let's get started on this.
Looks like you've maintained your tradition of having interns, whether remote or otherwise.
Yeah, I do. I have a few.
That's good.
So are we on the, is this the Wellington interest versus Joe Jockett's case?
Yes.
Yes, sir.
Okay. And I believe we're already on YouTube. Usually we don't do summary judgments on the record, but we can if you want to.
I don't need a record, Judge.
Okay. Mr. Leidick, do you need a record?
No, Your Honor, we're okay with that one.
All right, let's go ahead and proceed.
Thank you, Your Honor. This is the trespass to try title case. I'm assuming the court's had a chance to review the papers that
I have, but there's some kind of feedback when you're talking that makes it hard to hear you.
Oh, I haven't had that.
Do you hear that, Ms. Favela?
Yes, it's a little bit of feedback.
Do you know what that could be from?
It could be the mic.
Oh, it could be like maybe your mic is up against, do you have a mic on or?
I don't. Let me adjust. It's embedded in the monitor. Is it a little better now that
Something's
I got
making
closer?
noise.
I could log off of this computer and log on to my laptop and see if that's better.
It's up to you. It's just, you can, or you can just try to go forward. It's just a little hard to hear you.
Let me try to go forward and I'll slow down a little bit.
That's fine.
And,
ahead.
and okay. My client purchased this property at an assessment lien sale. And
I've read all the briefing, just
Okay.
FYI.
So what we're looking for, Your Honor, is a judgment in a trespass to try title claim. And for the damages, we have an affidavit with exhibits that are proffered to the court that are not contradicted or objected to. And just by way of background, I would tell you, Judge, that there was an FED that was filed that's hung up in the county court of law. And so we went ahead and we filed this in the hopes of being able to speed things along a little bit. I don't think there's any dispute that Wellington purchased the property, owns the property, has title to the property.
Excuse me, Your Honor, I object to that. I do object to it. That's the whole case.
Okay.
Sorry, I didn't mean to interrupt you there.
That's okay, Mr. Leidick. There's nothing that's been filed, Your Honor, that contradicts my client's entitlement to a judgment. And what we're asking for is a judgment that we have title to the property and for damages as laid out in the affidavit and the exhibits.
So I'm looking at your motion for summary judgment. So is it exhibit? It's a little hard to tell. Exhibit 2, maybe? Yeah, exhibit 2 is the general warranty deed. Is that correct?
That's the general warranty deed to the defendant, where
Okay.
she took title to the property in, I guess, 2008.
Okay. Go
Exhibit
ahead.
3, yeah, Exhibit 3 is the notice of lien, where the condominium association liened the property. And then Exhibit 4 is the assessment lien deed, where the association foreclosed and conveyed the property to my client.
Okay, and it looks like you have a certified copy of that, correct?
Those are certified copies, yes, Your Honor.
Okay. All right, response?
Response, Your Honor, on this is that although he says he has title to the property, my client has owned this property since 2008. It had a mortgage on it. She's paid off the mortgage, and all she has been doing is paying on her homeowner association fee. This has got to be worse than any PTA squabble I've ever seen, in that she and the homeowner association has gotten into a squabble, and then the homeowner association switched to a different management company, and that management company would not provide her with any information on anything. The first time she had notice of this was when she was sued in the JP court back in June. And luckily for her, although she didn't receive notice, a friend of hers brought her the notice that was stuck on the outside gate, not of her condominium, but of the whole association. And that was the first time she knew that anything had happened. And after reading what she has done, we defended this in the JP court, and right or wrong, the JP court ruled possession, although we alleged a title issue, and this case was already pending in the district court. The JP court went on ahead and ruled in favor of the plaintiff for possession, and we appealed it into the county court, which Mr. Harder, referred to. So what my client
Can I ask a question here real quick? Because
Yes, sir.
I'm a little concerned about one point, and I just haven't looked at all the exhibits. Because I've dealt with this pretty extensively, and I've actually dealt with this both in private practice and as a judge and
Yes, sir.
in front of the legislature. So under Rule 736, it requires that a condominium association foreclosure has to go through an expedited foreclosure proceeding that would be signed off by a judge and that the parties would have notice of. Was that process followed here or not?
It was not, Your Honor. And that's what he would have had this in here as his proof if it would have been so. And my client would have been served with a lawsuit as she was served in this district court. And that's been the whole objection of this foreclosure issue. And my client, we have an expert witness who's gone over the title documents, and his statement is that the recorded title documents that the plaintiff has filed in this case is insufficient as a chain of title, and they do not have a chain of title to the property. They don't even provide you with an index to the chain of title. And right, wrong, or indifferent, our expert says that Genevieve Jacques is still the owner of the property due to the lack of exactly what you said, the expedited foreclosure through the district court.
Your Honor, if I may correct the court, in a Chapter 209 proceeding with the Homeowners Association, a Rule 736 proceeding is required. This is a condominium association. It falls under Chapter 82, and it's Chapters 81 and 82, or 82 and 83 of the Property Code. In a condominium association lien sale, the code does not require a Rule 736 or any other judicial action. In a condominium association, it provides that upon the filing of a notice of lien, that is a sufficient predicate for proceeding to a foreclosure.
So you're saying it's not required. You might be right about that. It's usually mandatory homeowner associations. Huh.
And Your Honor, on this situation, we cannot find any proof anywhere that there is even a lien, except for what the substitute trustee says. There's nothing, not one scintilla of evidence saying there's a lien on the property by the homeowner association.
Well, Your Honor, if I may, I want to make 2 points. One is that there is a scintilla of evidence of a lien, and that's Exhibit 2 to the, Exhibit 3 to the motion. And the second thing is, Mr. Laddick is talking about his expert and his client's experiences and so on and so forth. I haven't seen anything filed in response to the motion that proffers any of that. I may have missed something, but I hadn't seen it.
Well, in this situation, Your Honor, it's been difficult to have service of process or even determine who to serve process on in this matter. And as you can imagine, during COVID, it's been difficult for this client to maintain any reasonable relationship with the homeowner association. She has allowed them to come into and repair things as necessary, but she still believes that she has right to possess the property and that she has paid off the property. And for a $3,000 lien, supposedly $3,000 lien, that this should not, the court should not grant a summary judgment on this, not just because of the equity, but because we have, by our expert witness, said there is not a chain presented to the court.
But did you submit an affidavit from him?
Yes, sir. It's my exhibit B.
Let me look at that again.
Okay. Well, then I'm at a disadvantage because I don't recall ever having received that.
The response or just that exhibit B?
Anything, not a response.
Okay. Your Honor, I have the receipt somewhere. I can find it if you'll give me a few minutes to look for it. That shows that it was accepted by the clerk. If you'll just give me a few seconds to look.
Okay.
And with that, we did give notice to the plaintiff.
Okay, well, I would just represent to the court. I had seen it. I see where Mr. Leidick filed something on the, I guess on the 19th.
I'm looking for it. Yeah, went too far back. It was, yes, sir. The notification of service was sent on the 19th, and it was accepted if you know, by the court the following Monday.
Okay, let me see exhibit B. Let me screen share this.
I see it, Your Honor. I was able to pull it up from the court docket.
So, Mr. Harder, I mean, do you see this affidavit from Mr. Gordon?
Yes, I do, Your Honor, and I think it's a meaningless document. I think it's up to the court to make the determination. And when it comes, you know, to have an expert, a supposed expert, testify as to the title documents, I think it's an exercise in futility. I think it's up to the court to decide whether or not the documents provided show a chain of title. And this person certainly doesn't explain why having the deed to Ms. Jotchitz with the notice of lien and then the assessment lien sale does not establish a chain of title showing ownership of the property in my client.
Your Honor, he mentions what a chain, he even says chain of title in his motion for summary judgment. And I think what, I'm not going to speak for what the expert says, but the expert says that that is not a chain of title. It doesn't show any of the documents filed by the homeowner association besides what the plaintiff wants you to see. If they want a pure chain of title, they should have an expert put the chain of title, show the clerk's the county recorder, as you know from your experience, Your Honor, there is a deed record search that they can do with the county clerk's office, and it will have a property it'll list the property by date order, and to chain a title together, it should at least have all the documents shown to the court, not just cherry pick some as the plaintiff did in this case, just to show that in this case they have the last deed.
Well, I don't know what more I need to show. And I certainly hope Mr. Leidick's not implying that we cherry pick documents. And if he thinks that there's some documents in the county clerk's record that somehow will speak to who owns this property, it would have been incumbent upon him to proffer that in contradiction to the position that we're taking. We've got the deed essentially from Ms. Jochett's grantor to her, the lien, and then the assessment lien sale deed. And so I'm not sure.
Mr. Harder, let me just say this. I'll give you two options. It seems like there was maybe a miscommunication or something about whether or not you saw this or whether or not you were properly served or whatever, but it is in the court's file, so I do have to consider it. You know, I agree with you. There may be deficiencies in this gentleman's affidavit, but you haven't raised them. And so I'll give you two options. I'll let you pass this summary judgment so you can review his response and, you know, file a reply or objections or whatever, or I can rule on it now.
Well, I would ask the court to go ahead and reset it then, and perhaps give me either 1 week or 2 weeks at whatever the court's calendar permits.
I can reset it now, or you can contact the clerks and reset it, whatever you prefer.
Well, I prefer resetting it right now. It'll save us all a little bit of time, and then whatever date that we're looking at, both Mr. Leidick and I could be sure that those work for us.
And Your Honor, Ken doesn't know about this, but it was just set this past weekend. I have a son in the military, and they're expecting their first child, and my wife and I are going to be in Florida for the birth.
Congratulations.
From the 10th through the 17th, we will be out of town. And I just haven't got my notice to the court or him of that as of today, but I can stay.
You want to do the 19th or the 26th?
If we're going to do this, I'd like to do it, you know, later in the month of April.
That's fine.
1st of May.
April 19th or 26th?
20 is better.
I could do the 19th, I think, Your Honor.
Does that work for you, Mr. Leidick?
I would rather have the 26th, Your Honor, because we are probably going to be back in town the 18th, and we will literally be out of touch with our first grandbaby from probably the 10th through the 17th, that we're driving to Florida and driving back.
That's fair. We'll reset this to April 26th.
Thank you, Your Honor.
You want to shoot for 3 o'clock again? Does that work for everybody?
Perfect.
I've got something in Judge Brown's court that day at 1:30. It's probably.
You want to do it in the morning then?
Yeah, morning would be better. My morning's clear.
How about 10:30?
That's fine. That works.
Mr. Leidick?
That'll work, Your Honor. Thank you very much for your consideration.
No problem. April 26th at 10:30. Okay, guys. You guys be safe, okay?
Yeah, and congratulations to you, Andy. You're ahead of me. My kids don't know how to make grandchildren.
This is the first one. We're excited. And you can imagine that my wife is pulling me to, let's get on the road.
All right. Well, good for you.
My kids just turned 21, so we're not ready for grandkids yet. But
okay.
Hopefully in the future.
Hey, mine's 33, okay? 33, Lieutenant Commander in the Navy.
Well, congratulations. That's great. We appreciate his service, or her service.
Okay, thank you, Judge.
Thank you.
Andy, we'll see you then.
All right, bye-bye.
Okay, bye.
Thank you.
Mr. Bassett, are you here for the 3:30 hearing?
Yeah, Your Honor, for Bodie versus Macy's.
Is your opposing counsel here? I don't see him.
I do not, Your Honor, and I strongly suspect he will not be.
Why is that? Are you you said they're not going to show up?
Judge, based on past experience, I would be surprised. He got notice of it, Your Honor.
Okay. I thought he filed a response to this, didn't he?
He did not that I saw, Your Honor.
Let me look. I have a lot of hearings today. May not be remembering that correctly. This is on the Bodie versus Macy's. Is that correct?
Yes, Your Honor.
Okay. Yeah, you're right. He did not file a response. So you're asking for, I'm a little unclear what you're asking for here. You want a dismissal with prejudice? It kind of explained to me what's going on here.
You bet. Your Honor, the case was initially filed in your court and state court. We got it removed to arbitration. In arbitration, the plaintiffs filed a motion for non-suit with prejudice. The arbitrator filed an order of non-suit with prejudice, but I believe we need to come back into your court and get the state court matter dismissed with prejudice as well.
Okay, that's no problem. I'll go ahead and sign it.
Very good. It's in front of the court. Well, I know that we submitted the order, Your Honor.
You did, and I just printed it out, and I'll go ahead and sign it by the end of the day and get it to my clerk.
Very good. Anything else the court needs from me?
Nope. Hope you're doing well.
Better than I deserve, and still, and Judge, I meant it the other day. I know I sent you around something. If you've got any young lawyers that you think may be looking for work when they graduate and they want to work really, really hard, send them.
Oh, hey, well, I was gonna, here, let me go off of YouTube.